Dear viewers, Namaskar and greetings. This week we have come with about 9 cases, of which one is a pretty large case, and of them there are 3 Supreme Court judgments, 3 or 4. So these are all important judgments, and I hope this will help you gain more knowledge about Insolvency Bankruptcy Code and also in general uh, what I would say legal parlance. So with this, I take you over to the next part of the video. Viewers, you can see Guide to IBC homepage on your screen. So initially, in the first phase, we are going to deal with 3 cases. Let us come to the first case. In this is a Supreme Court judgment pertaining to what is supposed to be a claim with regard to an MSME. And this you will find in Section 3, subsection 6, which pertains to claim, and also in 240A. The second case which we are going to deal with is pertaining to section 10, that is insolvency proceedings moved by a corporate entity or corporate debtor. So this is a particular case which we are going to deal with. The case is here. So, and the third case, which we will discuss, is Gaurav Katiyar versus Greater Noida Industrial Development Corporation, pertaining to jurisdiction, whether COC has the jurisdiction or RP has the jurisdiction, pertaining to revision of a claim. So let me stop the share here and take you to the slide. Now, in this particular case, in Sri Swami Samarth Construction Finance Solution and versus Board of Director versus NKGSB Cooperative Bank Limited. This doesn't pertain to Insolvency Bankruptcy Code. This pertains to a SARFAESI matter. With regard to MSME, there is a notification which pertains to which is known as Framework for Revival and Rehabilitation of Micro, Small and Medium Enterprises. But this doesn't, the matter went to Supreme Court. A notice under the company was, or the entity was declared to be an NPA. And the MSME had challenged whether the bank can possibly declare it as an NPA because it is an MSME unit. So the Honorable Supreme Court held that the framework does not prohibit lending bank or secured creditor to classify the account of the defaulting MSME as NPA. It is not duty of lending bank and secured creditor to run after all the all the borrowers and find out whether they are sick or not. It is the responsibility of the MSME also that they should inform the banks about their becoming sick or unable to pay, and that they, through duly supported by an affidavit, which you see here, and the lending bank or secured creditor, if it is will see if it is whether it is mandatorily bound to look into whether the MSME can come under the framework. Without that being done, the MSME cannot take the shelter of the framework, and the bank is fully eligible to declare it as an NPA. Now we move to the next slide. This is Goa Food and Pharma Private Limited. This is pertaining to Section 10, Topic 11. This particular company was not in operation since 2001. It did not have any assets or liabilities. It filed a Section 10 petition for insolvency. NCLT held that when company is not in operation since 2001, has no assets, no fund, investment, no purpose will be served by admitting it to Section 10. Because what insolvency? Insolvency is essentially for the purposes of rehabilitation of company, rehabilitation of a unit. So no effective purpose will be served by admitting it to CIRP. A question may come here as to where the company is supposed to in such a case. Will it go through Companies Act and file for liquidation? Winding up? No. I have in one of my podcasts stated that a company, it is perfectly legal, they can write to MCA to strike off its name. And the matter will end. Now, the third case which we had discussed was Gaurav Katiyar versus Greater Noida Development Company, Greater Noida Development Authority, in which a claim was revised based on developments. This pertains to Regulation 14, and you will find it in Topic 14 also. Now, in this, NCLT had forwarded, there was some revision of claims, and RP had reported, and NCLT had forwarded it to the COC. NCLAT held that the jurisdiction regarding revision of admitted claim based on additional information solely vests on RP, none else. COC has got no jurisdiction to decide about the status of the creditor. It is RP who is collating the claims, and it is his jurisdiction. So learned tribunal had made was an error in referring it to COC. So with this, we move to the next topic. Next case which we are dealing with is a huge case. This case is itself, you can call it about 5 cases at one place. It has been segregated to Section 62 in 2 topics, in Section 14, in Section 18. So this judgment itself is about 128 pages, and it's a remarkable judgment. You can find the case in a number of places. So, and it will take a lot of time. I would rather suggest, because everywhere the judgment is different. So I would strongly suggest that the viewer should look into all the topics, and along with that, the excerpts of the judgment. So let me stop the screen share and take you to the slides. So as you can see, this particular case refers to Section 14, Section 18, Section 62, and Section 62. Now, in this particular case, what happened was a CIRP had commenced on 22nd of February 2023. NCLT declared a stay order on 7th of March 2023. And on 10th of August 2023, NCLT has considered some matters, and they had discussed and had stated that all the other IAs stand closed. Now there was a question. The stay was vacated. Subsequently, the matter went up to Supreme Court also. And then when the CIRP actually started, the stay got vacated. Now, in between, initially Axis Bank had withdrawn 30 crores and other banks had withdrawn 145 crores. RCEL, who was also a part of the COC, they had strongly objected. Now, the first question which arose to the court was that what is the difference between a stay and quashing? Now, the court opined that order which has been stayed will not be operative from the date of passing of the stay order. However, it does not mean that the stayed order is wiped out of existence. unless it is quashed. So difference between quashing and staying is the original order stays. It stays in abeyance, but it's not quashed. In quashing, the original order is stayed. I mean, not no question of staying it, original order is gone. So in this, the original order stays. And obviously, it has an implication as to whether the moratorium, here the court opined that both appointment of the IRP and as well as moratorium, whether the court held that they are also stayed. But does it mean that the management goes back to the erstwhile owners? You will notice that I had mentioned you in earlier one of my podcasts that in the case of Mukesh Kumar Jain versus Naveen Kumar Upadhyay of 930 and 933 and 943, 944, 2023, NCLT had held that definitely no. The order of stay does not mean that the management will revert back to the old management. It is the IRP who should take care of that. But this particular question, in this case, was never discussed. So, but the management was, IRP had handed over the management. So we'll come to that in the later stage. Now we come to the point that with regard to withdrawal of money. Now NCLT, as I had mentioned, had stayed the order. And on 10th of August, they had mentioned that all the IAs stand discharged. Now, as I said, that Axis Bank first withdrew 30 crores and to which RCL objected. And in due course, all the others withdrew about 143.15 crores, to which RCL had continuously objected. Axis Bank came up with the objection that the matter is res judicata. Now, what is res judicata? Res judicata is a matter which has been adjudicated by a competent court. Therefore, it may not be pursued further by the same parties. But on 10th of August, the NCLT held that it had not discussed about these things. These things were not discussed at all. So when these were not discussed at all, the question of res judicata does not arise. The applications which were filed seeking reversal of the amount withdrawn by RC were never even considered on merit. So the concept of res judicata does not arise. Now we come to the next topic, which we go into. Yeah. So we come to the section 14. It says that doctrine of restitution will arise because the stay order is no more there. Now, what is doctrine of restitution? Doctrine of restitution in contract law dictates that when a contract is void or unenforced, any benefits and advantage that one party has gained must be restored. Now, the moratorium, what is the effect of declaring CIRP? Moratorium comes into operation. Now, just because the moratorium, the stay was there, it doesn't mean it did not give any jurisdiction on the financial creditors to withdraw money which was cities assets. So section 14 will be effective from the date the CIRP was in action. It was stayed. So doctrine of restitution will apply in section 14. And did apply here, and NCLT directed all the financial creditors who had withdrawn money to return it back to the corporate debtor. Now we come to section 18. Now section 18 says what? The basic dictate is IRP must act in the interest of corporate debtor and in accordance with the IBC regulations. IBC norms and CIRP regulations. Now, IRP had moved a petition. Now, petition was basically to state that that the court should declare that The CIRP, instead of starting on 22/2/2023, is starting on 10th of August 2023. The fact remains that the court observed that first question arose as to, even though the suspended directors informed the IRP that there is a stay, he had meekly handed over the management to the erstwhile directors. Was it not his duty to come to either to NCLAT or to NCLT and seek directions? Which he did not. He meekly handed over the management to the suspended directors, which was wrong. When RSAIL was strongly objecting to other financial creditors withdrawing money, and even the CD's management was objecting, the RP did not raise any voice. So he was not definitely looking into the interest of the corporate debtor. So court held that our IRP was in error. The entire application IRP was in error. So what we see, we have two new topics in section 61. What are the new topics? One is the order, when it is stayed, it does not mean that it is quashed. Second is applying the plea of res judicata can only arise when there is a proper adjudication in the matter. Number 3 topic, which is there in section 14, is doctrine of restitution. Applies in section 14. And of course, in 18, this is not a new topic, that IRB must act in the interest of the corporate debtor. This is very much there. So with this, we move to the next slide. The next case which we are going to discuss pertains to Regulation 2B of liquidation process regulations. It pertains to Regulation 2B is what? That any party can move a compromise or arrangement petition during the liquidation process of a company. Now, there are some very important findings by NCLAT in this matter. And let me take you to the slide so that you can get the highlights. Now, in this, what the court held, Prakash Oil Depot versus G. Madhusudan Rao. The court held that provision relating to timeline of Regulation 2B is directory in nature, not mandatory. Now, everything said and done, court first referred to sub-regulation 3 of Regulation 2B and said that no proposal of compromise or arrangement under Section 230 of Companies Act shall be entertained if it is not filed within 30 days from the date of liquidation commencement. If that is done, then the question arises. Now, the basic point is what? It depends on the commercial wisdom of the parties, means commercial wisdom of SCC, and the person who is proposing compromise. Now, if there are certain delays, it says that you know that in Regulation 2B, there is a period of 90 days mentioned there. The court held that that is not mandatory. That is directory in nature. What is required to be seen is whether the commercial wisdom of the parties are suggesting that, yes, a compromise is going to take place when they're serious about it. So court is going to look into the basic intention of the SCC. Because, why? Because the Regulation 2B is also a part of liquidation process. So with that in view, the court stated that, okay, 90 days period is mentioned. But provided if the scheme is moved within 30 days of liquidation commencement date. And then it does not end on the 90th day because of maybe multiple factors. But in such case, the court will allow extension of time if applied by the liquidator in due consultation with the SCC and the party proposing the compromise. So with this, we move to the next topic. In this particular segment, we are going to deal with 4 cases. The first case is of Section 67, in which it's a Supreme Court judgment, not necessarily connected to IBC, but will have tremendous implication on IBC also. The judgment is here. It's not a very big judgment, but an important judgment. Urmila Devi versus Balram. Now, the second case, which we are going to, as I say, this is with Section 67. The second case which we are going to deal with, we have one case in individual insolvency that's relating to personal guarantors. It relates to Section 105 of Insolvency Bankruptcy Code. That's Vicky Sukanraj Shah versus DBS Bank. This is also an important case, and this is a new case. So this is a new topic and a new case. So I would rather suggest the viewers to go through it. The third case which we are going to deal with is pertaining to Section 231. You can also call it pertaining to Section 63, which says that the only NCLT and NCLAT have the jurisdiction pertaining to Insolvency Bankruptcy Code. But you will appreciate that NCLT and NCLAT, they are not courts, they are tribunals. So herein, the question is dealt by High Court as to whether High Court can interfere. And the third case, and the last case which we are going to deal, is pertaining to 238A, that is limitation. This is a Supreme Court judgment of last week, and it's extremely important. The case is here. You can very well see it. So let me take you to the highlights to give you the judgments, the main highlights of the judgment. Now, in Urmila Devi versus Balram, the court held that court should quash those criminal cases where the chances of an ultimate conviction are bleak and no useful purpose is likely to be served by continuation of the criminal proceedings. The criminal process cannot be utilized for oblique purposes. So when we move a Section 66 petition, it is our duty to see that, yes, the element of fraud is there. And there's no point in moving a case which is going to prolong for 20 years. We are in a time-bound, and the IBC is a time-bound process. This particular case, though this is not related to IBC, was moving for 20 years, and wherein there was no element of fraud which could be proved. And court says that if the criminal case, there's no chance of ultimate conviction, what is the point in moving that case? The case should be the case should be quashed. Now we come to the next slide. This is Vicky Sukanraj Shah versus DBS Bank. Now in this case, there was the personal guarantors raised an objection that the facility granted under ECNGS scheme, that is Emergency Credit Line Guarantee Scheme, was not covered under personal guarantee. The Section 100 order had already been issued by adjudicating authority. So NCLAT was of the view that once order of 100 under Section 100 had attained finality, the personal guarantors could raise the objection through repayment plan. They suggested the personal guarantors to present repayment plans to the RP in which they can point this factor. So they did not go into the merits of the case. But it was a very valid suggestion given to the personal guarantors that if you have got some objection, why don't you mention it in your repayment plan? And it will be, the authority will look into the matter. Because this was not a case pertaining to objection of Section 100 petition. It had already identified it. So this is an important aspect and it's worth noting. That's why I selected this case. Now we come to the third case. This is Jaju Babu versus National NCLT. It was held by Kerala High. Now the first question which arose was, so does High Court have a jurisdiction? Because Section 63 and 231 make it specific that it is NCLT and NCLAT who have the jurisdiction. The Honorable High Court held the availability of alternate remedy will not be a reason for not exercising jurisdiction when there is a violation of principles of natural justice or where proceedings are challenged where proceedings challenged are without jurisdiction. In this particular case, what happened was this was pertaining to home buyers. And home buyers, the property was mortgaged. So some home buyers had bought the assets without obtaining NOC. Initially, they were allowed to be, part of their claim was accepted and they were allowed to be members of the Committee of Creditors as financial creditors. Subsequently, a financial creditor came and said that no, they should be removed from Committee of Creditors because the deed has already been executed and the assets of those parties are not assets of the corporate debtor. So NCLT agreed to that, and without even hearing the parties, they agreed to their being removed from the COC. The parties went to High Court. So High Court said, of course, that's not right. This was, NCLT had given a direction without offering the principles of natural justice to the home buyers. And so they took up the matter and referred it back to NCLT. So if principles of natural justice is violated or where the proceedings challenged are without jurisdiction, High Court can overrule and definitely look into the matter. The last case is very important. It is IL&FS Financial Services Limited versus Adhunik Meghalaya Steels Private Limited. This is a Supreme Court judgment, which said that what happened was a company had a very loan from someone. It was featuring in the balance sheet of the CD till the financial year 2017-18 or 18-19. When it came to balance sheet of 1920, the name of the financial creditor was not featuring there. So NCLT was of the view that there is no definite acknowledgement of debt by corporate debtor. Supreme Court looked into the matter. Not only that, they said that balance sheet must be viewed in the background of other admitted documents, including financial statements of previous years, to determine whether it constitutes a valid acknowledgement of liability. The balance sheet of 2019-20 was seen with balance sheet of earlier years. The court even went to seeing the cash flow statement and found that there was no repayment made effective to banks, to the financial creditor. So the loan which was being reflected in the balance sheet pertained to the loan which was existing in the previous year. So it held that definitely there was an acknowledgement of that. And further, In between, there was COVID period. So, suo motu order dated 10/1/2022 applied. So, the period from 15/3/20 to 28 to 22 would be stand automatically excluded. So, the period of limitation, taking into consideration, the COVID period and recording the acknowledgement that on 12 May 2020 would commence on 1/3/2022 and would continue till 28 to 2025. So this was very much within the period of limitation and could dispose of the matter. And this is definitely a remarkable judgment. This is an addition to Dena Bank judgment. Dena Bank judgment held that balance sheet entry in the balance sheet does constitute an acknowledgement of that. But this stated that even if the name is not there, the court is bound to look into previous year document and other documents and determine whether there is a perfect acknowledgement of it. So with this, we move on to the end part of our video. We have come to the end of our video. I hope you liked it. I would request you to please comment and express your views on the videos. In case you dislike something, please let us know so that we can improve ourselves. And your likes motivate us. Your subscriptions motivate us even more. We'll soon be coming with a revived guide to ibc.com website in possibly another 7 to 10 days' time. Bye for now.